34. I request all of the participants for, if anyone, it is possible to switch on the mic so we can keep this interaction interactive and it will not become monotonous or monologue from my side where I'm speaking and everybody else is like doing with their work. So I request who for if anybody it is possible to keep their cameras on. Thank you very much, Matthew sir. So it helps a lot when somebody is not speaking to a black wall and only your picture is moving. Thank you, Pramodji. Uh, so this is project-wise insolvency. Uh, the I have prepared. Thank you, Raviji. I have prepared the PPT slides, and there is three things which I principally want to discuss. One is the PPT slides, which is because it's required to be made. I have made, and that gives the basic fundamentals of project-wise insolvency. Second is few of the judgments, and third is the discussion paper. So I propose to start with the the fundamental basic, which is even prior to it, is the RERA Act. So what is the project-wise insolvency and why the people are thinking about this kind of insolvency? So the entire concept of project is codified in the RERA only. There is no definition of project-wise insolvency in IBC or any of the regulations, rules which has been framed under the IBC. And RERA is entire act is built on a project. So I'm sharing with you the BEAR Act, and in which we will see some of the important provisions and how they are built around this architecture of the project and the project registration. So let me share my screen. Yes. So here I have the RERA Act. This is just now downloaded from the website of the India Code, which is like nowadays updating really frequently. This act was enacted in 2016, and the necessity of this act was to regulate the real estate industry. So one of the preamble, from the very preamble of this act, the concept of the projects comes into it. If any of you have any of the questions or just want to share your knowledge, it is, I will be highly obliged if you wish to share it and speak during the session. So this is the RERA Act. This is the preamble. This act was to establish the real estate regulatory authority. So the first time in India, because of the RERA, the regulations was made for the real estate regulatory authority. Prior to this, there was no omnibus regulator for the industry, and everybody was working on ad hoc permissions which were obtained from the various departments and constructing the project. There was nobody to take care of the consumer interest. There are many consumer-centric legislations like Consumer Protection Act, Competition Act, and RERA is in one of those legislations which fall in that list. So the whole idea of making a RERA was to protect the consumers. And to protect the consumers, they made an authority which is called the Real Estate Regulatory Authority. So promotion of the real estate sector and to ensure sale of plots, apartment or buildings as the case may be, or sale of real estate project in an efficient and transparent manner. This is important. So what it stresses on the efficiency as well as the transparency, and to protect the interest of consumer in the real estate sector, and to establish an adjudicating mechanism for speedy dispute redressal, and also to establish the appellate tribunal to hear the appeals for the decisions, directions, or the orders of the real estate regulatory authority. and adjudicating officer, and for the matters connected therewith or incident thereto. So this was the first legislation. It is very contemporaneous to the IBC, but it has a specific subject matter and it was category. It is unlike the IBC, it is not omnibus. IBC, as far as the law is concerned, it is a general law. It applies to all the industries across all the sectors, and for all of them, it has a straight jacket, same formula which is to be applied. Anybody could move to the insolvency. Thereafter, the claims are to be invited. COC is to be constituted. COC runs the company as a going concern. In the meantime, invite the resolution plan. Post invitation of the resolution plan, the COC decides on the viability and approves the resolution plan, which is further subject to the scrutiny of the NCLT. And if nothing fructifies, the company ultimately moves to liquidation. So this is the straight jacket formula, be it a power plant or be it a atta chakri. There is no specific provisions were made when the IBC was originally enacted. Historically, being an economic legislation, it is prone to the changes, and the numerous changes were made. And one of the challenges in implementation of the IBC is that it was found that it is not a good law for resolving the real estate projects are concerned because they have sector specific problems. If we look into the jurisprudence of the other countries, it is easy to find that most of the IBC provisions are sector specific in many of the jurisdictions where they have different kind of provisions for the different kind of industry as far as the IBC is concerned. Realizing the difficulty that IBC cannot be applied in particular to the real estate sectors, the legislation and the judiciary tried to find out solution for various mega projects. And one of them was the first amendment in the IBC was regarding the reclassification of the financial creditor, where due to difference of the opinion between the various benches, ultimately the legislature has to step in and say that allottees in a real estate project are financial creditor, deemed to be a financial creditor. So first is the deeming fiction. So the deeming fiction was specifically introduced for the purpose of giving benefit to the consumer of this industry. And even that particular section, if we go to that particular section, that talks about all the definitions of the RERA. So first, let me just open the IBC and that relevant provision. Just give me a second. I'll open it. So I'm just going to just have patience for a second. So could anybody confirm whether they are able to see the IBC on the screen?
Yes, we can see, sir.
Thank you. Thank you. So just I'll come to the relevant definition. Yes. So this is in the chapter section 5. And when you see the explanation for this section, it says that any amount raised from an allottee under the real estate project shall be deemed to be an amount having commercial effect of a borrowing. Though it is not a borrowing, but they have, by a deeming fiction, assume that it is a borrowing. Because basically, if without constructing the flats, an amount is deposited to say that we will construct the flat. So it's a change of the cash flow for the purpose of the business or a builder. And therefore, they said that this is sufficient for the deeming fiction, and amount raised will be regarded as a borrowing effect. Therefore, they categorize the financial creditor. Further, the most important thing which I would like to emphasize is the expression allottee and the real estate project shall have the meaning respectively assigned to them in clauses D, ZN of Section 2 of Real Estate Regulation and Development Act of 2016. So from the very beginning, it was clear that as far as the allottee is concerned, what is an allottee? In a project, both the definitions are not provided, but they are referenced to from the RERA Act, and therefore the RERA becomes important. Now coming back to the RERA, it's a consumer-centric legislation. So first it's was the object. Thereafter, if we come to the definitions, we will scroll through some of the definitions and which will demonstrate very specifically that everything in the RERA is derived from a project. So first definition is advertisement. Advertisement means any document described or issued as an advertisement through any medium and includes any notices, circulars and other documents or publicly in any form informing person about the real estate project. So by way of an advertisement, what the businessman is doing is advertising the real estate project or offering for the sale of plot, building, apartment, inviting persons to purchase in any manner of plot and etc. So from the very beginning, the very first few definitions is related to the project. Similarly, the allottee's definition is also related to the project. So what it says, allottee in relation to a real estate project means the person to whom plot, apartment or building as the case may be has been allotted, sold or otherwise transferred by the promoter and includes the person who subsequently acquires the said allotment through sale, transferred otherwise, but does not include a person to whom such plot, apartment, building as the case may be is given on rent. So every person who is more than a tenant is an allottee in a project. That's the purport of this definition. Then next, common areas. Even in the common areas, it is an interesting thing that the entire land or the real estate, it will be a common area. So everything in the project is connected in the RERA for compliance purpose, for transparency, increasing the transparency. So next important definition is OC, which we sometimes called occupation certificate, completion certificate. So completion certificate means of such other certificate by whatever name is called, issued by competent authority certifying that the real estate project has been developed according to the sanction plan, layout plan and specification as approved by the competent authority. One of the challenges for the IBC was that when somebody gets a license to develop a project, there are multiple towers and there are multiple projects within the projects. Each project is not separate when originally the proceedings were initiated. So how to segregate them? So it was one of the challenges. OC is also one of the challenges. Like if there is some deficiency, taking example for the Gurgaon, Haryana, still the problem persists. That if there is a builder has made a default in any of the project, even those projects where there is no default, the authorities do not allow them to get any further certification and etc. They say that you first remove your default in that particular project, and even other viable or those projects which are completely going fine are denied permissions. So that was also one of the reasons why this project-wise insolvency is coming. And this problem is particularly very very serious in case of the completion certificate. Now, another thing important is that RERA introduced the thing of like estimated cost of the real estate project, which is and includes the cost of land, taxes, cess, development, and other charges. This can be connected with your cost of the resolution plan for the IBC. EDC, external development charges, and other things like garage, and all these things are contentious issues in the resolution plan and post approval of the resolution plan. Now, another thing is internal development work when it is relevant. So means, words, footpaths, and everything which is for the benefit of the entire project is relevant here. Now, the most important definition, which doesn't define as such but gives reference to the other definition. One is project. Project means the real estate project as defined in ZN, and promoter. Who is the promoter? So their law is yet to settle whether the landowner will be regarded as a promoter or not. To my understanding, a person who construct or causes to be constructed an independent building or a building consisting of the apartments, or converts the existing building or part thereof into apartments for the purpose of selling all or some of the apartments to other persons and includes his assignee. So he is a promoter. So there also the definition is yet to settle. A person who develops the land into a project, whether or not a person also construct the structure on any of the plot for purpose of the selling or other persons and all or some of the plots in the said project, whether with or without structures there, he will also be regarded as promoters. Now, RERA envisages that a prospectus has to be issued and regarding a project, and that has to be a transparent process. Now the definition is actually comes into the ZN, and this is the section which has been referred into the IBC, which we have just gone through. So IBC section says that as far as the definition of the project is concerned, explanation, it says that go to ZN, and we are back in ZN, real estate project. Means the development of a building or building consisting of apartments or converting or existing building or a part thereof into apartments, or a development of land into plots or apartment, as the case may be, for the purpose of selling all or some of the said apartment plot building as the case may be, and includes the common area, the development works and all improvement structure thereon, etc. So this is a very generic definition, and challenge before the people who are trying to interpret it, definition is how to find out whether a particular building is the project or all the buildings in that particular plot of land is a project. So that question is not answered as far as this definition is concerned. Sanction plan is always related to a project, and that's where a part of the answer comes out. What is the project? Sanction plan means site plan, building plan, service plan, parking, landscape, etc. If applicable, permissible, such permission which are approved by the competent authority prior to the start of the real project. So, one, if the plan is approved regarding a project with all those distinctions, then it might be regarded as a project. Then the final thing which is important is, which can be conclusively said that a particular thing is a project, is comes from a registration. So the entire chapter 2 of the RERA is dedicated to the registration. Initially, in some of the resolutions plans, and even today in many of the resolution plan, the people are trying to get exemptions from RERA for the reasons that the requirement of the transparency in RERA is significantly higher than what it used to be when these projects were originally conceived. So, what could be done and what are the prohibitions which makes it important? No promoter shall advertise market, book, sell, or offer for sale, or invite person to purchase in any manner any plot, apartment, or building as the case may be, in any real estate project or part of it, if any planning area without registering the real estate project with the RERA established under this act. So no advertisement could be made. Now the challenge is in most of the cases which are in the IBC regarding the real estate projects were conceived when these provisions triggered in 2016. Post 2016 cases, it is really easy to identify whether it is a project or not and what are compliances required to be done. Be that as it may be, it is the thinking of the policy maker that if in the existing projects which are happening in the real estate sector through IBC, the resolution plans are getting approved, then it is advisable to get them registered in the RERA for protection of the consumer. This is largely the thinking of the policymakers. So this is the RERA requirement. Then everything here is related to the project. All the definitions are related to the project. Then one has to make an application under section 4 for registration of project. Next few sections which are important is after the grant of the registration, if the registration is not revoked, then functions of the promoters and the duties of the promoters kicks in. And that is why in the project-wise insolvency, the role of the promoter becomes crucial and the promoters are involved in such insolvencies. So first is functions and duties of the promoter. So why there is a combination between the IBC and the RERA and why, what is the discussion which is going on? This topic became relevant because recently the IBBI has released a discussion paper last month, I think 11, last maybe in couple of months back. I'll give you the exact date. And because in that discussion paper, they have advocated the project-wise insolvency and they propose certain changes in the regulations framed under the IBC. So what are the obligations of the promoter becomes important. The idea behind those changes was to make the incumbent or the person who is coming as a resolution applicant bound by the provisions of the RERA. So he has all the obligations in the RERA while completing the project or implementing the project. So section 11, the promoter shall upon receiving his ID and so as the case may be, create his web page on the website of the authority and enter all the details of the proposed project as provided under so, including the following: details of the registration, quarterly up-to-date list of the number and types of the apartments closed as the case may be, quarterly up-to-date list of the number of the garages booked, approvals taken, and the approvals which are pending subsequent to the commencement certificate, status of the project, such other information and document as may be specified by the regulation made. This is already happening in many of the cases. So where you visit the website of the RERA Development Authority, all those details are given. Sometimes they are not up to date, but this is the foundation which is casted upon the promoters of the real estate project. Sorry. Then the next thing is an advertisement and the prospectus issued published by the promoter shall mention prominently on the website address of the authority where the all details. So the entire emphasis is on the transparency. The promoter at the time of the booking and issue of the allotment letter shall be responsible to make available to the allottees the following information: sanction plan, layout plan along with the specifications, approved by the competent authority by display at the site and such other places as may be specified by the regulations. The stage-wise time schedule of the completion of the project, including the provisions of the civic infrastructure like water, sanitation, electricity. The promoter shall be responsible for all the obligations, responsibilities, and function under the provisions of this act or the rules and regulations made thereunder, etc. The promoter will also be responsible to obtain the completion certificate or the occupancy certificate or both as the case may be. C, the promoter shall be responsible to obtain the lease certificate from the real estate project, etc. D, it should be responsible for providing, maintaining essential services. So, series of obligations has been casted upon the promoters, which has been given in detail in this particular section. And all those obligations are coming back to either the existing promoter who is giving the plan in the project-wise insolvency because of the MSME reason or any other reason, or any person who is trying to become a resolution applicant or the resolution plan has been approved. So obligations of the promoter regarding the veracity of the advertisement or the prospectus. So these sections are something similar to what we see in the SEBI, regarding the disclosure. So a promoter is bound to disclose all the true and correct information, and all those information has to be publicly available and to be made available to the stakeholders. This is the central theme of the section. 13. No deposit or advance to be taken by the promoters without first entering into agreement for the sale. But for the purpose of the today's topic, is the most important section is 14. Adherence to the sanctioned plan and project specifications by the promoter. The proposed project shall be developed and completed by the promoters in accordance with the sanction plan, layout plan, and specifications as approved by the competent authority. Notwithstanding anything contained in any law, contract, agreement after the sanction, layout plan, specification, fixture, so and so, as the case may be, are disclosed or furnished, so and so, and etc. So there are multiple conditions. So what is important here, that in case the IBC is to be applied, and because of the proposed amendment, if this section is to come, then a person who is structuring the resolution plan, his option gets reduced. It will be difficult for him to change layout or increase the number of units in order to generate more revenue and make the project viable. So there are structuring limitations which are coming on the people who are entering into this business. Similarly, there is a restriction on transfer which is built in the RERA. So they cannot actually transfer it, but with the IBC, it could be done. So one of the structuring thing which has been introduced in the RERA is not in sync with the IBC, because in IBC as a resolution plan, it is deemed, or it is incumbent that everything has to change from the hands of the incumbent to a new resolution applicant. So this is section 15, transfer of title. Then rest of the things in this particular act is not relevant for today's discussion, but this is what is here. And this is why the project-wise insolvency is. So I'll just close these files and we'll come back to the main topic. So as far as so far we have seen that the RERA is a consumer-centric resolution, consumer-centric legislation, clearly emphasizing on the transparency and adherence to the plan and many of the ethics. Now it is all coming to the IBC. Let me now go to the presentations. I have prepared the Would you like me to go to the PPT slides, or you would like to go to the discussion paper first? Any answer, any suggestion?
Discussion paper.
Okay, great. Thank you, sir. So I'll just go to the discussion paper which has come in, and so the discussion paper I'm sharing on the screen. Share. That's a good suggestion, and that helps me a lot. So the discussion paper, it's 6th November 2023, and it all started with the first judgment with the Umang Realtek. Then it went to the Supreme Court in other judgments, and thereafter Mr. Amitabh Kant's reports, and there are multiple judgments. But the best thing about the IBBI's discussion paper are that they are very comprehensive and they covers everything.
Can you increase the size a little bit to fill the screen?
Yes, sir, I'll try. Is it okay, sir?
Yeah, thank you.
Okay. I have to reshuffle my windows a bit. Okay, so, right. So the discussion paper deals with the following issues. It says mandatory registration and extension of the project under the RERA. This is the first and foremost thing they are trying to come up with. Second, operating separate bank account for each real estate project. In RERA, it is mandatory to have an escrow account in which all the money is received from the allottee is to be deposited. And the promoter can take only a specified percentage to his own account, otherwise it has to be deployed. So they want to bring that discipline here. Execution of the registration of sublease deed with the approval of the committee of creditors during the corporate insolvency resolution process. So one of the challenges many of the real estate projects were facing was that during the CIRP, some of the towers are fully constructed where the possessions are already given or about to be given or can be given on fit out conditions, like the consumer can make their fit outs. But because of the moratorium under section 14, it is not, they are not allowed to transfer the title of the property to those particular allottees. There was no clarity on it. So there was a specific suggestion made, execution of the registration deed. COC to examine and invite separate plans for each of the project. In IBC, one of the biggest challenges, it is against a company. It is never against a particular project. And one of the fundamental canons of the IBC, that the promoters or the shareholders who are having the control of the company are substituted by the committee of creditors who have lended the money to the company as a management so they can run it, and because the shareholders are not able to run it efficiently. In case the management is not substituted for the company and it is only for the project, it means that the promoters are not going away from the company as such, but only in relation to the particular project. Exclusion of the property in possession of the home buyers from the liquidation state. This is one of the most important suggestions, where in case there is no resolution plan, then there is no, the consequences as per the IBC would be to liquidate the state. And if we liquidate the state and there is no transfer of the ownership to the allottees, liquidation automatically means the sale of the asset. So allottees gets nothing out of it and there is a risk of his dispossession. So this particular problem is also, they are also trying to address this particular problem. So one of the key features which has led to is the Amitabh Kant's committee's report of the real estate project. This report came few months prior to this discussion paper. This report suggested many radical changes in the real estate sector, in which they proposed that all the financial creditor will waive off their interest on the principal. It will be developed again, and the promoters will be removed. And there were many radical suggestions. Some of these suggestions are being implemented in the UP. It's not omnibus. It does not have throughout India application as such, but what the IBB is trying to do is they are selectively picking a few portions of this report based upon which they are proposing the changes. So first it says the committee was formed under the chairmanship of Amitabh Kant on the issue related to legacy-styled real estate projects, recommended that the IBC need to be reformed to better accommodate the complexity of the real estate sector. Some recommendations in respect of the reforms are as under. So this is the first time they have thought it proper to say this is not a IBC is not one size fit for all. Project-wise CIRB. All the projects need to be pre-registered with RERA. Since RERA registration is project-wise, this can be adopted under the IBC. This is the first and foremost. Second is transfer of ownership / possession of the allottees. The committee proposes that the IBC may enable resolution professional to transfer the ownership and possession of a plot, apartment, buildings to the allottees during the resolution process. An option may also be given to the allottees to acquire such unit as is where is basis on the payment of the balance required to be completed the unit during the process. Houses which are under possession of the allottees should not be included in the IBC process. This suggestion is really good for the home buyers as far as consumers are concerned, because they will be able to take possession of their flats if they are complete. They will be able to take possession of the flats if they are ready to be fit out, like if all the superstructure is complete and only the furnishing is left. Thirdly, those people who have already taken the possession, they need not be the part of the insolvency process. The logical conclusion maybe the CIRP cost might not go on to them. They will not be thrown out of their property. So this could be the consequences if this is implemented as such. Then thirdly, registration / transfer of ownership where possession transferred. Where possession of a plot, apartment, or building to the allottees have already been transferred, these transactions must be formalized through registration during the CIRP or a project-specific resolution process under the IBC. So this is also a radical suggestion. The challenge is that an authority will not allow registration of a particular property or a flat to which the possession has been given because there is no OC or a completion certificate with relation to that particular project. So they are trying to carve out an exception that even in those cases where the OC might not have come, but the possession has already been given, those people or consumer need not suffer the process of the IBC. And the registration and transfer of ownership can take place because possession only is half of the title. Like without registration, the validity to the title doesn't come. The registration is a very integral component, and so is the possession. If you the project, if the registration is there and no possession, still it is not a good title. So they are trying to combine both and try to give maximum advantage to the consumers of the real estate projects. Now the next. The colloquium of the functioning and strengthening of the IBC ecosystem in November so recommended as under improving the outcome of the real estate cases. One thing which these policymakers are being challenged in and day out prior to the IBC, during the IBC, and even till today. Maximum amount of case load in the National Consumer Redressal Forum, NCDRC, and IBC are the real estate project, and in most particularly in the big cities like the NCR or Bombay and etc. And not only the quantum of the cases is huge, but also number of people affected in these projects is also huge. There was some report yesterday it was aired in some media, which was saying that even today, more than 5 lakhs people are still waiting for their flats and access in the NCR region. So this is the magnitude of the problem, and therefore they are trying to find a solution which mitigates the problems of the customers. So 4.8 recommendation number 3, the code may provide that a resolution mechanism tailor-made to address the need of the real estate sector be specified with the necessary variations from the CIRP.
कौन कहता
Including project-wise admission and resolution, delivery of the completed houses to the home buyers during CIRP, allowing home buyers to become resolution applicants.
हो नाही ते राहू दे ते का मी आता एक व्हिडिओ कॉन्फरन्सिंग मध्ये तुला नंतर सांगतो काय
सुजीत जी, आपके कमर्शियल सीक्रेट्स आउट हो रहे हैं, so thanks for keeping the video on. Just coming back to the topic again. So the last suggestion, which is not covered in the earlier paragraph, is allowing home buyers to become resolution applicant. So the first time they are contemplating a situation where home buyers have been, anybody can be a resolution applicant who has not been prohibited from being so under 29 Act. That's the criteria. Even the ex-promoters can be a resolution applicant if they do not hit those particular provisions A and H, and the project is registered as an MSME. But for the first time, the discussion is going on regarding the reverse insolvency. Reverse insolvency has been talked a lot, but there is no formal recognition in the law, legislation in particular, where it has been recognized. But it has been recognized by the judiciary, and that process is going to be formalized if this suggestion is implemented, allowing the home buyers to become resolution applicant. So this is also in some way connected to the project-wise insolvency. The challenge, if the entire company goes into the insolvency, that some of the people are well placed in regarding to the construction payment, and some of the people are the worst place. So the project or the entire company may go into the insolvency because of a particular building which is not performing, commercially not viable, and the consequences comes to all projects equally. So the people who are particularly involved in that particular project, they can give an insolvency plan. So that will obviously means that the people in the project can give resolution plan for their own project. So what is the rationale? A large number of real estate cases has remained unresolved for long period of time, as the current framework of the CIRP is not conducive to address the issues specific to this sector. In the real estate cases, CDs have multiple projects that are at different stages of construction. The prospective resolution applicant are more inclined to take over the projects closer to the completion than those at the early stage of the constructions. So they are saying that it's easier to find the resolution applicant for the projects which are close to the completion, and instead of the thing where they are far from the completion. There exists situation where default is related to one particular project, while the other projects are on track, but the initiation of CIRP put the other projects also under the duress. Several experiments have been attempted by the courts to address these issues through the reverse CIRP and project-wise resolution. Thus, there exists a pressing need to have a separate resolution mechanism for real estate sector. So they said that judiciary has already done, but it is necessity to make the things formal and make necessary changes in the law. In view of the foregoing discussion, it is considered the above recommendation may be dealt through regulations to address the issue in the insolvency process of the real estate projects. Now, mandatory registration and extension of the project under the RERA. So, if we relate back these particular sections and this particular thinking to the provisions of RERA, we will realize how the policy makers are thinking, what they are trying to achieve it. So they are again falling back on the section 3 of the RERA. So first paragraph says, according to section 3 of RERA, all real estate projects are required to be registered with the respective state RERA where the area of land proposed to be constructed exceeds 500 square meters or number of apartments proposed to be constructed exceed 8. Existing projects where the completion certificate or occupancy certificate has not been issued are also required to comply with the registration requirement under the Act. So this was the requirement. This particular aspect was challenged by some of the builders. Ultimately, up to the Supreme Court, it was held that if the project is not complete, the registration is mandatory and the builder cannot refuse to register it on the ground that they conceived the project earlier and during the meantime, the RERA has been implemented. Thus, it is the duty of the insolvency resolution professional, IRP or RP, to ensure that all real estate projects undergoing CIRP are registered with RERA in terms of section 17(2)(e) of the code. So we have to go back to section 17 to see what are the requirements. But after finishing this paragraph, we will reopen that section and see what are the things which the resolution professional, because most of the people are the resolution professional and what they are supposed to do. Probably there will be some tweaking might be required, some concession might be required before that registration can happen. The registration of the real estate project is essential for ensuring more transparent, accountable and efficient projects process. The project registration under RERA enhances transparency and accountability as per the norms of the RERA, which is sector-specific legislation, which in turns can significantly enhance the prospects of a successful resolution. So this is what it is. And what they are casting,
बोला हाँ
what they are casting upon the resolution professional is duty to register.
हाँ
So we come back to the process of the registration. So that I think was section 11. Just a second. Just a second. Just a second. So application for registration is 4 and 5. So I will come back to section 4 and 5. Yes. So what the RP is supposed to check in his arsenal whether he has that following information or not. Every promoter, so we must read it, that every resolution professional shall make an application to the authority and which with such fees as the case may be. The RP shall enclose the following documents. Brief detail of the enterprise, including name, registration, address, type of enterprise, etc. And particulars of the registration, the name or photograph of the promoter. 2. The brief detail of the project launched in past 5 years, whether already completed, being developed, etc., etc. An authenticated copy of the approval and commencement certificate from the competent authority obtained in accordance with law. So this is going to be a challenge for many of the resolution professionals. And where the project is proposed to be developed in the phases, an authenticated copy of the approvals and the commencement certificate from the competent authority for each such phases. The sanction plan, layout plan, specifications, proposed project or the phases thereof, and the whole project as sanctioned by the competent authority. Sometimes all those informations are not made available to the resolution professional by the promoters, and sometimes those permissions which are required to get those registrations are not there. So the job of a resolution professional is getting more onerous in terms when they are taking up the real estate project. Even today, it's not an easy to handle a real estate project, but it's going to be different and more challenging in if these suggestions are implemented. The plan of development works executed in the proposed project and the proposed facilities to be provided thereof, including so and so facilities, etc. The location detail, G. The pro forma of the allotment letter, agreement to sell, and the conveyance deed proposed to be signed with the allottees. The number, type, carpet area, apartment sale projects along with the area, etc. So all that information has to be now provided by the resolution professional to the RERA authorities for the purpose of the registration along with the whatever the fee is required. Then provided that the promoter shall withdraw the so the D is one of the important considerations on which they are harping. C also you can take into account the time period within which he undertakes the project. It was becomes for the resolution applicant. D is important. The 70% of the amount realized of the real estate project from the allottees from time to time shall be deposited in a separate account to be maintained in a scheduled bank to cover the cost of construction and the land cost and shall be used only for that purpose. So this is where they are coming from, why there is a separate escrow account. Provided that promoter shall withdraw the amount from the separate account to cover the cost of the project in proportion to the percentage of the completion of the project. This is also important. Provided further that the amounts from the separate account shall be withdrawn by the promoter after it is certified by an engineer, an architect, and a chartered accountant in practice that the withdrawal is in proportion to the percentage of the completion of the project. So all those certifications are required to be given. Provided also that the promoter shall get his account audited within 6 months after the end of every financial year by a chartered accountant in practice and shall produce a statement of accounts duly certified and signed by such chartered accountant, and it shall be verified during the audit that the amounts collected for a particular project have been utilized for that project and the withdrawal has been in compliance with the proportion to the percentage of the completion of the project. So the requirement is audit is also coming, and probably it will also become a responsibility of the resolution professional to do that. Schedule bank is the schedule bank. Everybody knows, no clarification required. He shall take all pending approvals on time. This will become the responsibility of the RP, that he has furnished such other documents as may be prescribed, rules, regulations, such information as may be prescribed. And then the grant of registration. So one of the challenges which might come up in the future is the question, what if the resolution professional is not able to meet all those criteria? Whether the authorities in RERA will still grant a registration to a project which is already defaulting. That is the thing which the future will answer. Right now, we do not have answer to that problem. So what happens is, on receipt of the application under Section 4, authority shall within a period of 30 days grant registration subject to the provisions of the Act. rules and regulations made there and provide registration numbers, including login password to the applicant for accessing the website to the authority, and create a web page, fill therein the details of the proposed project. Reject the application for the reasons to be recorded, and if it is registered, then it is registered, and there is a process of the challenge as well in the subsequent section. So this is what will happen in all those projects if the registration is made mandatory under the RELA. So the proposal, what is the proposal? To expressly state the IRP and RP must comply with the provisions of the RERA Act and regulations framed thereunder. It is proposed to mandate the IRP and RP to register all real estate projects under the RERA, or to extend the registration of real estate projects under RERA wherein the registration is expired and about to expire. So this is an additional duty which is going to be casted upon the resolution professionals. Now we have already seen the provisions regarding the RERA, maintaining the separate account, and this has also been captured into this particular discussion paper. Now I'll read this. Operating a separate bank account for each real estate project. Under RERA, each project is registered separately and given a unique identification number. We have already seen. The approvals, filing, etc. are done on all the project basis. RERA registration facilitates systematic record keeping and mandates project-wise separate accounts. Developer management is required to maintain and provide detailed records related to project. These records, which include financial statements, legal documents, and construction status reports, aid in tracking the progress of the project, identifying potential issues, and informed decision making. However, the real estate projects during the CIRP project-wise bank account are not being maintained currently in many of the cases. Operating a separate bank account for each real estate project will record all the receipts and the payments of the individual project. This will facilitate information about a particular project which may be useful for the project-wise insolvency or for inviting separate resolution plans for a particular real estate project. So essentially, project-wise insolvency means that not only the projects will be identified, but there might be 10, 15, 20 projects and then 15, 20 resolution plans. In some of the cases, what has happened so far is the dual resolution plans are invited. They have also invited project-wise as well as the entire company. If these suggestions will be implemented in the future, the notion will be very clear that whether as a resolution professional or insolvency resolution professional, you are supposed to invite the plan only for the projects or for the entire company. That confusion will go away. Next. So what is the proposal? In line with the RERA provisions, maintaining separate accounts for each project and to ensure transparency in the process, it is proposed that IRP, RP should operate a separate bank account for each project undergoing CIRP. So this is an additional duty which is being casted upon the resolution professional. So the proposed amendment. It is proposed to insert the following regulations in the CIRP regulations 2016 registration. The interim resolution professional or resolution professional, as the case may be, shall register the real estate project of the corporate debtor under the RERA if the project of the corporate debtor is not registered under the Act. So if there is no registration, it is the duty to register. If the registration under the RERA of a project of a corporate debtor admitted in the corporate insolvency process is about to expire or has expired, the interim resolution professional or the resolution professional, as the case may be, shall seek extension of such real estate project from the concerned authority. So it's the duty to keep the registration alive as well. Opening project-wise account. The interim resolution professional or resolution professional, as the case may be, shall operate a separate bank account for each real estate project. So execution of the registration sublease deed with the approval of the COC during the CIRP. So this is the next limb of this discussion paper. It strictly does not relate to the project-wise insolvency, but it's still connected with the theme because this is a sector-specific legislation. This means that all these amendments are only related to the real estate projects or a real estate industry. And in this thing, only this kind of experimentation could be done. So the sum and substance of this particular suggestion is that consumers' right must be protected at all cost, be it through the registration, be it through the possession, and he should be not made part of the CIRP process if he is already done what is supposed to be done or got the possession, etc. I'll read it. For a business under the CIRP, the IRP/RP needs to ensure continuity as a going concern, as we have seen, which may involve the acquisition and sale of the inventory. However, the real estate sector presents a unique challenge. In some cases, creditors have fulfilled its part of obligation in the contract, and the corporate debtor has also constructed units, but formal handover is pending. So this is the specific problem. At present, the court in their inherent power have permitted the transfer of ownership, registration of the plot, apartments or building in few projects during the CIRP. So in many of those cases, when the IRP has taken such action of transfer, the court has given the permissions. They have cited one such example. The Honorable NCLAT in company appeal in the matter of Alok Sharma versus IP Constructions Private Limited observed that the rights of home buyers cannot be affected adversely in the corporate insolvency resolution process, and their interest is to be appropriately preserved and protected within the parameters of insolvency and bankruptcy code. So what was the direction issues? Direct the resolution professional to execute the sale deed after collecting dues and cost, if any, remaining unpaid, including cost of registration, penalty, and other incidental costs till date. So if as long as the home buyer or the allottee, as the case may be, is ready to pay or perform his part of obligations, the court is supporting in his all endeavors that he should not be troubled with the CIRP process. It is important to note that everything in this discussions paper started with the report of Mr. Amitabh Kant. That report has been implemented particularly in UP and Noida, but that report does not cover the commercial establishment. It's only for the home buyers. But be that as it may be, most of the suggestions which are coming in this discussion paper are centric to the allottees who have purchased the plot or a residential unit. There are many projects which are completely commercial in nature, and the clarity is yet to come as to what will happen in those projects and how they are going to protect those allottees. Because the definition of the allottee in the RERA doesn't discriminate between the person who has purchased the home or the person who has purchased a shop. But the policy report of Mr. Kant is specific to the residential projects. Now it is to be seen how they are going to implement it in the future regulations. Most probably, as far as RERA registration is concerned, it is omnibus, so it is going to apply in all the cases where the project is residential or a commercial one. So the fourth point, however, with view of a larger public good and considering the plight of the home buyers, there is a strong case of allowing transfer of immovable property in appropriate cases if the concerned stakeholders, that is the creditors, have approved the same. So there is a twist there discussing about approval by the creditors. This will potentially reduce the dispute at the adjudicating authorities and as well. Thus, where the allottees have paid the full amount and occupied the units or possession of the plot, apartment or building to the allottees have already been handed over to him, the transaction need to be formalized through a transfer of such unit during the resolution process with the approval of the COC. Further, units which are under technical possession of the allottees should not be included in the IBC process by the resolution professional. So what they mean to say and what are the questions which this particular paragraph poses is that a person, once he becomes the allottee, he becomes a creditor. Because of the deeming fiction, he becomes a financial creditor and part of the COC. So if one want to give the possession to such a financial creditor, then he is going to take the decision which is the part of the COC, one interested party in or out. That would be one of the questions. Secondly, if a transfer deed is executed, then he may no longer remain the creditor because his debt has been paid off. So the challenge will remain whether during the CIRP process, the composition of the COC will keep on changing or not. Then what will happen to the waterfall mechanism and what will be the impact of the prospective resolution applicant which is going to come into these projects. All the numbers will change because if before the resolution applicant comes, a particular deed is executed, the resolution applicant will not be able to ask any higher amount from such people. Even if he asks, nobody will pay to it. So what will happen? So with these suggestions, the multiple challenges are going to come, and to which the solution has to be found out by the resolution professionals and the regulators at the same time. So for the units as is, where is basis. So this is another thing. So one of the things which has now become popular is the fit out position, like where the structure is complete, the plaster is complete, the flooring is done, and now the internal fittings have to be done. So many of the builders are reducing the cost of such flats and asking the allottees that if you want to do the fit out, you do it at your own cost. So whether that is permissible and to what extent. So the concept of as is, where is basis is also coming. It has been observed that in few of the cases, allottees are interested in taking possession of the unit on as is, where is basis. Basically, this English phrase means in whatever condition it is, good, bad, worse, whatever, in any case, would get remaining development interiors of their homes finishing from balance fund which have not been paid by them. So it means that if you are taking a fit out possession, then you can not force a home buyer to pay the entire amount. The sum amount has to be refunded back, or he can choose not to pay the entire amount if he is taking the flat or the allotment as is, where is basis. The objective in the resolution of the real estate project is a smooth handover of the unit to the rightful home buyers. Thus, to expedite the resolution process and avoid delays due to unnecessary holdups, the allottees can be given the option to take possession of the units on as is, where is basis, or on payment of the balance amount, if any, after taking into account the funds due and funds required for completing the units after approval of COC. Once units are handed over, the registration sublease should be done. So as is, where is possession could be given, sublease could be done, and everything has to be with the consent of the COC. The challenge for such a thing would be, in some of the cases, the COC members have gone up to the Supreme Court and said that the home buyers or the allottees does not have a right more than what the secured creditors have. In all those cases, the Supreme Court or court was forced to intervene to say that the financial creditors cannot remove the allottees or home buyers from their flat to recover their money, to protect their interest. So it would be interesting to see where the CSC's composition is heavily tilted in the favor of secured financial creditor, and the people in the COC, which comprises allottees, are less in numbers, then how they will approve those proposals. But be that as it may be, those will be very few cases if the project-wise insolvencies are going to be implemented, because one of the objections in the prior cases was by the financial secured creditors, they have given loan to the companies as a such. Therefore, and entire project, including the successful and unsuccessful project, was the part of the company. Now they cannot be forced to give out the cream thing and suffer the losses. But be that as it may be, so far the intent of the legislature or the policy makers is clear, which they are trying or proposing to implement is to protect the interest of the consumers and giving it priority to the interest over the secured financial creditors who are purely lenders. So what is the proposal? To facilitate the smooth handover of the occupied units or where possession has been transferred to the home buyers, it is proposed to allow RP to hand over the ownership of the plot, apartment or building to the allottees through transfer during the resolution process with the approval of the COC. Further, to avoid delays due to unnecessary holdups, it is also proposed that with the approval of the COC, RP may be permitted to hand over the possession of units to the allottees on as is where is basis on payment of balance amount, if any, after taking into account the funds required for completing the units. These are the cases where some of the cases has already happened where this has been allowed by the NCLT, or where the RPs have taken the just decision to give over the possession of the units to the home buyers. So the RP in those cases where they are handing over the possession, they have to determine the amount, that how much has been paid and what is remaining to be paid in case they are giving as is where is possession. The proposed amendment, it is proposed to insert the following regulation in the CIRP regulations, handing over the possession. After obtaining approval of the committee with not less than 66% of the total votes, the resolution professionals shall. Few things important here. The percentage has been kept as same as the resolution plan, 66%. That is a very unique provision. So merely because the home buyers are 51%, they won't be able to pass this resolution. 2, the terminology is shall. Thereafter, the resolution professional will not have any discretion not to implement the resolution. Hand over the possession of the plot, apartment or building, or any instruments agreed to be transferred under the real estate project where the allottee has performed his part under the agreement and facilitate registration, or provide an option to the allottees to acquire such unit on the payment of the balance required to be completed the unit during the process, provided that the units which are under the possession of the allottees shall not be part of the assets of the corporate debt. So these are the few of the things. One of the challenges here is that sometimes the allottees are ready to take possessions where the projects are not fully complete, like the infrastructure are not fully developed, because they are facing the serious problem where they are paying the rents, when they are paying the EMIs, and they are faced with two hard choices. On the one hand, they are financially suffering. On the other hand, the house or the flat which they have bought is not ready for possession. Even in such cases, they are ready to take possession because surrounding infrastructure is not complete. They think that they can take possession. In those cases, the RP is bound to give. the possession. But the RERA requires completion of all those formalities, which includes the common areas and etc. So the resolution plans and any other post handover things has to be taken care during the structuring process. Those things have to be taken into account. And when they are specific, it is not yet clarified in this proposed amendment whether they will be formed part of the COC or not. But to my understanding, when they say that if somebody has taken part of the possession, then they will not remain the financial creditor or a deemed financial creditor, and they will go out of the COC. That's one part of it, but that's just an interpretation. The final words are yet to come. Explanation. For the purpose of handing over the possessions, the allotee are required to pay all applicable charges or to do all the compliances as per the terms of the shell deed or allotment letter or instrument for the transfer or possession of the sale deed, which shall not be inconsistent with the applicable law. So this is a small window which has been given. So you can still write in some of the resolution plan that even the people who have already received the possession, though they are no longer part of the COC or they are no longer CIRP, they are bound to contribute to the charges which are necessary for the development of the project. Those clauses might be drafted, will be drafted. What will be the implication will be decided by the future and by the adjudicating authority and the appellate authority or the Supreme Court, as the case may be. Now, any questions so far? Let me just check the chat box if there are some messages. I think most of them are the
Sir, can I ask something?
yes, please.
RERA is a very thin organization. Can it monitor all these things?
Sir, theoretically, they are supposed to monitor everything.
Suppose I know, but I find that it's a useless body.
That's true, because the people who are manning the RERA are the same who used to approve the building plans earlier in the authority. So what is happening that only the shape has changed, the people have remained the same. And because of which these things are cropping up, because you find the same attitude of the people who were earlier there and now they are in a different form and a different power. But the things have improved drastically if we compare to what it used to be in 2016 and now it is what is in 2024. So the things have changed. The hearings are taking place, and now last week or last to last week, they are given extra powers or additional powers to implement their orders. So far it was a toothless body, like they had no mechanism to implement their coercive orders, like a recovery of the payment, financial penalty, and etc. and etc. So the central government has already issued, I think it's an advisory note to all the authorities to give them the powers which has been given in the Gujarat RERA, that should be implemented across all the states. So in that case, they will give the coercive powers to implement their order. And as soon as that order will come, the logical effect would be that the people will become more compliant. So absolutely, you are right. The things are not at the best, but in future, they are going to improve for sure.
But I'm not denying that there are some improvements, but let me put the perspective from the point of view of home buyers. Okay. RERA is a centralized body, and and as an ordinary individual home buyer, I can't approach it. Okay. If you make a legal comparison vis-a-vis a consumer dispute redressal forum, it is present in every district in the country by virtue of its the act and enactment. But RERA is a centralized, it exists in one part of the state. How many people can afford and approach it?
That's a real problem. It doesn't exist in every state. But in UP and Haryana, I'm acquainted with the two states where the most of the complaint comes. So most of the things have gone online. So you can file the online complaints and the hearings are taking online. So as far reachability of the authority is concerned, it's no longer that much problematic as it used to be. The problem with the consumer forum is that they are not a specialized body meant to deal with these things only.
I agree. I know. Disagreement on that.
And they do not have the data source and the powers which are available with the RERA, because the RERA has data regarding all the allottees.
Yeah, of
As
course.
far as the consumer forum is only an adjudicating authority.
No, I am putting that's why I'm putting from the perspective of an ordinary home buyer. Okay. For a home buyer, see, unless and until what you said as a digital way of filing it and digital way of administering it, if it comes, okay, well and good. Otherwise, I'm telling you, it is still difficult for the ordinary home buyers, as an individual home buyers, to even 2 or 3 people join together also is difficult to reach and have to fight out if they have got a real case.
Yes, that's true. That's true. And in IBC, it has become more difficult with 1 crore and 10% and 100.
Exactly.
And even if you have the order of the
home
RERA or
buyer, only I
consumer
can
forum,
go to IBC.
yeah. And the problem is that even if, like in many of the cases, almost all of the cases that people have filed complaint in the RERA, got an order, they filed in the consumer protection, they got the damages order, they went to economic offense wing, registered the FIR, in some cases they got arrested, the promoters, and after they have done all this, the company goes into the IBC.
Correct.
And then everything comes to a standstill.
Yeah.
Like even the 138 cases, cheating, forgery cases, etc. So that's the real problem. But the thing is that so far the IBC was not tailor-made for this particular industry. And there are unique challenges to this industry. Private, like the entire business used to happen in cash and everything. The prices are listed something else, actually marketed selling something else, and the raw material is not available, green tribunal is coming in between, there are so many permissions to be obtained. It's a very difficult business to be in, and at the same time, from a perspective of an allottee, it becomes even more challenging because they have to trust the people who have a track record of failure. So those challenges has to be addressed at some point of time, but few of the things which they were able to save is like, say, in multiple insolvencies, there are few good examples where they are able to resolve it. But some of these suggestions are really good. In many of the projects, just like the giving of the possession, like as soon as if you got the ownership and papers and the possession, it's much better a situation than getting stuck up anywhere else. So fortunately, the discussions are going in the right direction. Hopefully, they are going to get it implemented from the home buyer's perspective.
Yeah, that's important. And also, sir, when I asked that initial question from the view of a regulation and supervision, when we say that in the advertisement such and such is there, when we say that they should not operate each project separate bank account, see, unless RERA is able to enforce and monitor it, provisions are good enough. But can the unless the RERA is able to monitor it, there is no use for that.
So that monitoring is going to come. It is there in the Gujarat. And if that suggestion is central government suggestion is implemented by the respective state, it's going to come into the respective states as well, where the RERA is not only regulating, but monitoring and implementing.
Let's hope so.
Yeah, let's hope so, sir. So COC to examine and invite separate plans for each of the projects. So that this is why the project-wise insolvency comes to a culmination point. Generally, the CD, which is associated with the real estate, has multiple projects that are at different stages of construction. Some projects have been completed, some are partially completed, and some are at the initial phase of construction. However, investing in all projects by one resolution applicants require huge capital and thus limits the number of the resolution applicant. This is one of the biggest challenge they are facing so far. And this is why, because there is no resolution. Because suppose a property raise, the number of people who can buy a property of say 50 lakhs is too much. But a person who can buy a project of say 500 crores or 1,000 crore are very few. You can count them in fingers in a particular locality or a particular business district. So this was one of the problems, and that is why it is better to do the project-wise insolvency, because at least the number of people who can apply for resolution of that particular assets gets increased. It increases the competition, and with the increase of the competition, the efficiency increases. It is often seen that some resolution applicants are not interested in all projects and wants to undertake specific projects. That's also a thing, because a person, say, who is a very good builder, but he has specializing of doing things in the Noida where law works in a specific fashion. He might not be very efficient to take on the project of the same company in the Gurgaon, which is the different jurisdiction. Further, the economic preposition of various projects, say one is closer to the road, one is underdeveloped area, are different. And therefore, the people can't give a straight solution to each and every project. And therefore, also it is important to implement the project-wise insolvency. Moreover, multiple builders of different projects could yield better value. So increasing competition, increasing efficiency, what they are talking about in this paragraph. So what is the proposal? In view of the foregoing discussion that each project needs different treatment in the terms of resolution, it is proposed to clarify that COC on examination may direct the RP to invite separate plan for each project. So role of the COC is crucial. So for each project, a separate plan is to be invited. It is proposed and the approval of the COC is a must. So like the central theme of the IBC from the very beginning has been that they have limited the discretion of the adjudicating authority in all these matters. From the very beginning, they emphasized that the commercial decisions are better to be taken by the commercial people. So the powers have been given to the COC. Right now, all the project-wise insolvency were made possible because of the judicial intervention, because the judiciary says that even if there is no provision, we direct, you can do it, and it was done. So they are putting the powers back from the hands of the judiciary in the hands of the COC, where COC will direct the resolution professional to invite the separate plan for each project. If it is refused by the COC, then it will not be able to do the RP will not be able to do the project-wise insolvency. It would also encourage. So the next line, it would also.
I have a doubt here. Can I ask now?
Yes, please.
Sir, does it mean that then doing a project-wise resolution is only optional based on the COC's decision? Is it
Right.
like that, sir?
Right, sir. So far, this is the proposal. And just in two paragraphs, the reply is coming from the discussion paper itself. So this is the proposal. And the final proposed amendment is in the next paragraph. I will read specifically. Thank you for the question. So it would also encourage the association of allottees of a real estate project to bring their own resolution plan and resolve the issues in a specific project. So what is the thinking is that a flat buyer or a allottee will not be interested in the resolution plan is what is happening in the another project or another tower. So probably it's more likely that multiple flat buyers can come together and provide a resolution plan for their own project. And that's also they are increasing. That's why they are incorporating these amendments to give more participation and more say to the flat buyers. So what are the proposed amendment? Proposed amendment following clarification may be inserted in Regulation 36A4 of the CIRP regulation clarification. The resolution professional on the proposal and approval of the committee may invite separate resolution plan for each real estate project or group of project of the corporate data. So approval of the COC remains the central theme. And thanks for that question. And the answer is here. So this is what the proposed change is. That the COC approval, without the approval of the COC, it can't be done. The approval of the COC will remain central. And exclusion of the property in possession of the home buyers from the liquidation state. That's very interesting, and that will provide solution of many of the problems, and at the same time will raise some interesting questions. In August 2018, the IBC was amended to clarify that the home buyers hold the status of financial creditors. The rationale was to safeguard the interest of the home buyers who invest their life saving in purchasing properties, ensuring that they are not left in the lurch if the developer faces insolvencies. Bona fide home buyers act in good faith when they enter agreements and pay for the properties. However, there is some confusion in the market as to whether the properties where the allottees have taken possession but the registration with any authorities of the transfer is pending are to be included in the liquidation state or not. Jurisprudence laid out below 2 points towards different pronouncements, including properties of the home buyers when they have fulfilled their part of the obligations would create several difficulties. So they have already faced this problem. So what will happen in case where the project is half developed? In half of the cases, the possession and registration is done, and half of them is not, and the company goes into liquidation. What will the auction will happen, and how the new person can come and redevelop this property when he can't move the few of the home buyers? At the same time, what would be the status of these people where the whole completion certificates or approval cannot come because the company has went into the liquidation and the project can't be completed? So these are the interesting challenges, and to which even the judiciary has not provided any clear-cut answer so far. So few of the judgments cited here is, one is the Pradeep Kumar versus DocCom. It has been held that there is no bar on execution of sale deeds in the favor of allottees even during the moratorium under section 14 of the code. So this is the first line of the argument, where it has been held that the logic or the reasoning behind this argument is it's a going concern. The whole business of the company is the buying and selling of the units. It has to be kept as a going concern. So there is no bar under section 14 which restrains the RP from doing or executing the sale deeds on the behalf of the company, even during section 14 moratorium. That's one line of argument. In another case, Ashok Sharma versus IP Construction, this was decided as following. It's just different approach which the adjudicating appellate authority has taken. The CD is the owner of the commercial space and has accepted that the possession was with the appellant admittedly. The appellants are allottees of the commercial space in so and so. Although CD has handed over the possession of the commercial space to the appellant, admittedly no sale deed was executed by the CD in the favor of allottees prior to the commencement of the CIRP. The house so constructed is the business of the real estate company, and the value of the sale of those houses will always appear in the credit side of the profit and loss account as revenue from operations. Hence, this is an asset in case of real estate company, as it is a recurrent business activity for the company, and it is its business for continuation of operation as a going concern even during the CIRP. We are unable to sustain the view of the respondent RP that these houses registration will violate moratorium under section 14 of the code. The registration of all these houses is the procedural requirement in case of real estate company where the appellants are already in possession of these spaces. The right of home buyers cannot be affected adversely in the corporate insolvency resolution process, and their interest is to be appropriately preserved and protected within the parameters of insolvency and bankruptcy code. So this was another example. In the matter of the logics developer, the NCLT directed the resolution professional to hand over the possession of the flats and take all necessary steps in furtherance of the same as required under law to ensure lawful and peaceful possession of the residential flat in the favor of the applicants. So AU Small Financial Bank versus Coral Infrastructure, Jaipur bench permitted RP to hand over the flats after compliance of the statutory provisions. And the Supreme Court in the Bikram Chatterjee held. So this is important and important to understand. So I'll read it. We have also found that the non-payment of dues of the Noida and Greater Noida authorities and banks cannot come in the way of the occupation of the flat by the home buyers, as money of the home buyers has been diverted due to inaction of the officials of the Noida and Greater Noida authority. So here the main objector was the Noida or Greater Noida authority, which was taken as an argument that if the landowning agency itself has not been paid, how the registration could be done. And in Noida, what happens is that the registration has to be done with the Noida Development Authority because they are the owners of the land. Just a second, I'll just take a call. So we have also found that non-payment, yes, this was the authority. They cannot sell the building or demolish them, nor can enforce the charge against the home buyer leased land project in the facts of the case. Similarly, the banks cannot recover money from the project as it has been invested in the projects. Home buyers' money has been diverted fraudulently, thus fraud cannot be perpetuated against them by selling the flats and depriving them of hard-earned money and saving of the entire life. They cannot be cheated once over again by sale of the projects raised by their funds. The Noida and Greater Noida authorities have to issue the part completion certificate as the case may be to execute tri-party agreement and register deed in the favor of the buyers on the part and completion or the completion of the building as the case may be where the inhabitants are residing within a period of 1 month. So for these reasons, they have stated that, okay, it cannot be done for like these are the arguments, but the court was not happy with those arguments. All those were rejected and the direction was to give the permission and affect the registration. Without these orders, it is impossible to get the registration done in the Noida. Similarly, in Taravi Ramchandra Ravichandan and so, it's in the case of Chennai. So north and south, same situation. Thus, in order to protect the interest of home buyers and also in order to do complete justice and keeping in view the intricate, unique facts and circumstances of the present case, we are of opinion that the project GRT grant 71 flats that are sold should be kept outside the purview of the liquidation state of both the corporate debtors. So they are also not allowing these assets to be part of the liquidation state. Fundamentally, in the IBC, the exclusion is relating to the statutory dues regarding the provident fund only. That there is a specific provision that these funds have to be kept out of the CIRP process. Now, the second exception is probably going to come forward is the assets in which the possession has already been given. They have to be kept out of the CIRP. So whatever is the resolution plan or whatever is the other things which is to happen regarding the company or in relation to that project has to happen regarding the unfinished flats or where the possession has not been given. The details of the order in relation how the excluded assets are to be treated as dealt with in the later portion of this order. So this was the order. So another approach was coming in the, this is Samruddhi Realty Limited. had entered into a sale agreement in 2011, making full payment and had taken possession of the nearly completed villas in 2016. These allotted filed an application to exclude the property in their possession from the liquidation state for its registration in their favor. Despite the fact that the full payments were made by these allottees for these properties which were in their possession, NCLT ruled in May 2023 that since no sale deed was executed, the property cannot be excluded from the liquidation state. This was also affirmed by the NCLT, highlighting that no security interest was created in the favor of applicants, and without a registered sale deed, they had no ownership rights and thereby denying them any relief. As can be seen from the above, that judicial pronouncement in the areas of real estate mixed. This creates problems that requires immediate redressal. So this is the challenge. The two approaches have been taken by judiciary so far. In one line of the cases, they are saying give it. In another line of cases, they are saying that no, nothing doing. In one line of cases, they are saying that they will be outside the CIRP. Another line of cases that they will become part of the liquidation state. And this is the precise problem which this discussion paper is trying to address. So what is the proposal? The proposal is section 36 of the code defines the liquidation state, which states that for the purpose of liquidation, the liquidator shall form an state of the assets which will be called the liquidation state in relation to the corporate debtor. Clause 4 of section 36 code states that the list of assets which shall not be included in the liquidation state shall not be used for recovery in the liquidation state. Section is further provides that the board to specify any other asset which shall not form part of the liquidation state of the corporate debtor. Board may specify that assets in possession of the allottees be excluded from the liquidation state. So the only state and the power is with the board. So probably this amendment can come sooner. Now the challenge will be that if there is no resolution plan forthcoming, most of the people will run for the possession in whatever form it may be to protect their interest. Because the interesting problem will come that under the waterfall mechanism, they are the deemed financial creditor, and above them, there is further a category of the secured financial creditors. And secured financial creditors will take their share first if they have a security interest. So if you want to avoid the waterfall mechanism, you can do so by asking for the possession of the flat as is where is basis. So in cases where the companies have not completed the construction, but they are going into the liquidation, it will be beneficial for allottees from a structuring perspective or a perspective to protect their interest, to ask for the fit out possession or as is where is possession. So at least their units are not going to be sold. But whether this option will be available to those people where the construction activity has like very raw construction is going on, and what will happen where the flats are existing in the air, those questions are yet to be tested. And when they were tested, I hope there will be a progress in the favor of the allottees, because the whole idea is to protect their interest. So what is the proposed amendment? It is proposed to modify the insolvency, bankruptcy, liquidation process regulations and to make following changes. For the purpose of so and so, an allottee as defined under the clause of Section Real Estate Regulation Act in the possession of unit, it shall not form part of the liquidation state of the corporate debtor. So this is what it is. So this is what it. So these are the in broad discussions and proposals and the changes, and therefore the IBBI invited suggestions. The windows were open. Everything, anybody could have given the suggestions. Most probably they are going scrutinized, and the history of the IBBI is that they are very fast as far as the suggestion implementation of the suggestions are concerned. So now what it does is it compiles all those suggestions which are given above and put it in the form of the regulations, and that's why this is the end of the discussion paper. So far, any questions? I'll just stop the.
I have a couple of questions, sir.
Yes, sir.
Sir, one question is, what is defined as a real estate project? Like in the sense, is it mandatory that it has to be registered with RERA, or if the activity is real estate but not registered with RERA, will it still be considered as a real estate project, sir?
Sir, the real, sir, I could not get your name, but I.
Gopal Krishnan, sir.
Gopalji, thank you.
Yeah.
Thanks for the question. This is a really important question. So, if you recollect, in the very beginning, we have seen the provisions of the RERA. In RERA, they define the project, and the definition of the project is further referred to clause ZN, which defines the real estate project. So, the real estate project is anything which is going, particularly like there are state-wise nuances. There are some changes in different states, because this is a subject matter on which the state can legislate. So there is not a complete uniformity, but the broad parameters that if it is more than 500 square yards, then it is required to be registered if it is not completed or the construction is starting after 2016. So if any of those criteria are filled up, then the registration is required. In case the builder has not registered, the discussion paper says that it will be the duty of the IRP or the resolution professional, as the case may be, to get the project registered under the RERA and make all the compliances which are necessary.
Okay, sir. So the criteria is to determine what type of business it is, rather than registration or not. If it's a real estate project which gets covered as under RERA of the state, then irrespective of registration, it comes as a real estate project. Correct, sir?
Right, sir. That's what I think, and that's the approach.
Yes. Then my second question, sir. Now now that we have said that it will be going to be project specific, even if the CD is a non-corporate, can it trigger a IBC process just because it's a residential, sir? Suppose it's a residential project with RERA registration, but the CD is a non-corporate, will it still come under IBC, sir?
No, in my considered opinion, it will not come under the IBC, because IBC is very limited to the corporate persons. But recently, the chances of that happening is very difficult, because most of the developers, to secure their interest, after the super tech case, they have decided to incorporate a company for each of the project. So it's very difficult to find a project which is a proprietorship or a partnership. But if it is the case, if it is a proprietorship or a partnership, you do not need a CIRP to recover your dues, even otherwise. Like I'm assuming hypothetically some proprietorship person is taking over a construction activity of 100 flats. Okay. So in that case, the CIRP process is even otherwise not required, because you can take all the actions in the consumer protection, RERA, etc., criminal complaint, and that will be effective because there is no corporate entity coming in between. So far there is no requirement. Further, in the existing IBC, the individuals or the partnership firms cannot be taken into. So only the corporate entities against which these proceedings are meant to and applicable to. So the answer to your question is negative, in my opinion.
Thank you, Manish.
Thank you, Gopalji, for the question. Any other questions, sir? We still have like a lot of time for the discussion, and 1 hour more to go. I wish to finish it within the time. It will be really helpful if you people come with more questions and etc. Till any further questions comes, I'll take you to the few of the landmark case laws which have come on this issue. So, I have created a short PPT and which I wish to share. Just a second. So this PPT broadly covers what is what is just a second, let me share it. Share. Okay, so this is the PPT I have created. Most of the issues we have already covered, but still it is effort. So this is like, so definition of the project-wise insolvency. This was one of the questions which was posed. It gets state-backly related to the RERA. And initiation by the various stakeholders is still there. Like for initiation, you have to meet the parameters and anybody can initiate, be it the allottees, financial creditor, operational creditor. Then, so the objective of this is to maximize the value for all stakeholders involved, timely completion of the project. Limited to the project specified in the initiation, no influence on the projects with different landowners, financial institutions, or the allottees. So one of the benefit which will flow is that sometimes there are multiple landowners. If the other project is situated on the another landowners, or if there is another lender in that particular another project, so the effect of the lending and the ownership gets restricted to a particular project. This is one of the advantage of the project-wise insolvency. Stakeholders involvement. So involvement of the various stakeholders in the resolution process, balancing the interest of the allottees, financial creditors, operational creditors. So if somebody has supplied, so for a particular example, if somebody is supplying the iron bars and the cement, then he will become the operational creditor of with that particular project or through the companies. And how they will find out which iron bars were supplied to what. That will also become questionable, but the records has to be seen, and the challenge will be very serious when there are no records which were maintained by the corporate debtor or the promoters or not handed over to the resolution professional. This is still one of the biggest challenge for the resolution professional, and this is going to be remain the challenge in future as well. So expeditious delivery is the one of the main goals of the project-wise insolvency. So basically what they are trying to achieve is they are trying to catch the low-hanging fruit and say that, okay, this is achievable, you just take it and go home and be happy. Those things which are difficult, we will see in the future what happens. Value maximization is their legal framework. They are trying to make it more official with the implementation of the suggestions. Ensuring stakeholders harmony. So this is something very generic. So one of the argument which is given so far by various judicial bodies in the favor of the project-wise insolvency, and they always compare India with China. So both the countries, there are very large-scale developers who are suffering insolvencies. In China, it is Evergrande. In India, maybe it is Supertech or Kamrapali or many others. So what they say that the China is still struggling to find out a process by which they can resolve the insolvency of the Evergrande. But Indian judiciary has found some solution in the form of, say, Amrapali or JP, where they have tailor-made or tweaked the legal process to suit the project and therefore provided a solution, even in the case of the super PAC. So what they are saying that every project has its unique requirement and unique challenges, and in order to meet that requirement and challenges, They need a different solution, and therefore they are advocating for the project-wise insolvency. So that's the argument which is advanced by the judiciary to strengthen the case of the project-wise insolvency. With the help of the discussion paper, the policymakers is saying that it is all right, the argument is valid, the point well taken, but it is going, the ball is going from the court of the judiciary again to the COC, where they will be finally decision maker what is to be happen. What is to happen. So next is, so what is the need for the project-wise insolvency? So these are the things. Increasing intense, there are real estate companies which are defaulting. The data from the IBC as of September, challenges, comparative analysis, and multiple things they have done. So there are many amendments which have already we have discussed. There is a report on the functioning of the system, which we have already seen some of the part, and this is the argument of the tailor-made insolvency. I will share all those slides with all of you, so you can use them, and it might be helpful. I hope we have already gone through this paragraph, so I'm not repeating it again. The next thing is key recommendations. So tailor-made solutions, variation from the CIRP process, including project-wise admission and the resolution. Emphasis on the importance of the delivering the completed house. Additional recommendations, advocate for allowing home buyers to become resolution applicants. Empowering the Real Estate Regulatory Authority of India, role similar to the financial regulators. Rationale for the tailor-made resolutions, challenges, unique and etc. All these things are the generic points. Next is, so all these issues we have, because discussion paper was very exhaustive, so we have covered all these issues. So I'm not repeating them again. I'll straightforwardly jump to the judicial pronouncement which has been cited succinctly here. Just a second. Let me come to the relevant slides. Yes, so these are the judgments which have first is the Flat Buyers Association, Mental Hills, Gurgaon, and second is the Umang Real Tech Private Limited. They are cited as a poster case for this kind of insolvency. So what has happened in this first case? Rachna Singh, Ajay Singh initiated CIRP against the Umang Real Tech. The tribunal accepted the application and directed financial creditor to deposit 2 crore for expenses. The Flat Buyer Association appealed, expressing hindrance to the project completion during the CIRP. So this was the case, the issue. The scope of CIRP against the real estate company limited to the concerned project or extend to the other project. Preference between the financial institution, banks, and allottees flats upon and allowance of the funds to the allottees. So what arguments were? So the appellant said that CIRP is affecting project completion. So what they argued is that since there is a CIRP is commenced by the people who are affected by an unfinished project, it is affecting even those projects which are going well. And that was one of the arguments which was taken by them. So as that the CIRP proceedings should be dropped. So requested stay on the recovery proceedings, asset utilization, project completions, because everything comes to a standstill with the imposition of the moratorium. The project cannot progress, and therefore they advocated the implementation of the CIRP. And the observation of NCLT that the CIRP against the real estate company should be projects specific, not affecting other projects. So this was held in this case. Secured creditors should not have a preference over the allottees or for the projects. This was also held in this case. Refund claims by the allottees cannot be entertained, citing the CIRP process. So these were the key parameters which were laid down in this particular case, which strengthen the case of the reverse CIRP or the project-wise CIRP. So the judgment NCLT specific CIRP real estate companies rejected the clubbing of the CIRP of different projects, emphasized equal treatment of the secured and unsecured creditor, and disposes of the appeal with this observation. Ultimately, this case was attained finality. Like there are no, to my knowledge, there was no further appeal pending. So there is another case, Ram Kishore versus Union Bank of India, in which also this has happened. So in this case, Section 7, there were around 20 projects, including the Eco-Village Stone. All project CIRP is going on. So reference is made whether now this is the builder in this case is the Supertech. So whether it should be a project-wise or whether it should be for the entire company was the question before the court. So NCLAT basically said that they said that experimentation is normal, and they adopted the project-wise resolution as a test for the success of site. So in this case, the COC was constituted only for the particular project, which was Eco-Village 2nd, and in which the financial creditors and home buyers were included, and directed RP to continue with ex-management assistants keeping separate accounts. So the promoters were not removed as such. However, everything was supposed to take place with the supervision of the resolution professional and with the assistance of the resolution professional, and proposal expenses, challenge the adoption of the CIRP, and etc., etc. So all those things are there. The Supreme Court ultimately held, the order was challenged of NCLT in the Supreme Court. The Supreme Court examined the tenability of the proposition of the project-wise insolvency, and they decided not to interfere the directions of the project-wise insolvency given by the NCLAT. It was further stated that the ongoing projects were continued with the IRP's active assistance and refused to interfere with the directions of the project other than the Eco-Village state. So this is where the project-wise insolvency argument was further strengthened. This is one of the landmark case where the very big builder, only a small portion has gone into the insolvency. Then Whispering Towers Welfare Association, again another case. In this case also the similar thing has happened. NCLAT's decision, they sought permissions. COC approved the project-wise resolution plan, and this was approved by the NCLAT. So this is the successful case where the project-wise plan was given to the COC. COC approved it. It further passed the musters of the NCLAT. So the Supreme representation by the home buyers led to the inclusion of the project-wise resolution on the agenda. So basically, the entire thing was spearheaded by the homeowners or the allottees. This agenda was approved by the COC. The objective was cited as the maximization of the value. The adjudicating authority questioned the COC's decision, which was overturned by the NCLATs. And it was upheld that the project-wise insolvency could be done. So this is the case, and so in summarize, we can say that the project-wise insolvency is going to come, and the changes are bound to take place, and it's a positive steps. So many of the people will get the relief, and ultimately it will be good for everybody, every stakeholders. But at the end of it, the work of the resolution professional is going to increase significantly for sure. Any further questions? I assume that everybody has understood everything. It was not monotonous, or everybody completed whatever they are doing so far. Number of participants. Any questions, sir? Yes, so there is a question. So it's only says yes, sir. Ma'am, any questions do you have, Preeti ma'am? Or you have understood everything? Either way.
I have an observation, sir. Gopal Krishna here.
Yes.
Though from a flat buyer's perspective, it is a good move. Don't you think? From the CD's perspective, it is allowing them a opportunity to exit from wrong business decisions they have taken on a particular project and continue to be a going concern as far as other projects are concerned.
Yes, you are absolutely right. It has given them a window. So they can shelve off something which is not working, but they can still remain under the control of the company. So that's a window available to them, and probably they will take benefit of it. So that's a valid observation, sir.
Okay, sir. Thank you, sir.
Thank you, sir. So, would you like me to want to go through the cases like line by line, or we conclude this session with the permission of moderator?
Sir, one thing, although not directly related, I just want to raise a point again from the perspective of home buyers. Okay. See, by the time a real estate projects reaches the IBC, the actual loan which he has taken must have already gone into NPA. So far, any of the rights, any of these discussion papers were silent on. He's affected, his credit score is affected for somebody's mistake. What is your comment on that?
Matthew, sir, my personal experience in all these real estate projects are that.
Your voice is very low.
Am I audible now?
Yes, sir, now audible.
Okay, so my perspective on these companies are that most of these companies do not have any loan from the financial institutions. The reason being that if you can take the money from the home buyers, it comes almost for a zero interest. So what these companies did is to take more money from the home buyers, and they hardly took any loan from the financial institutions because the interest rates are very high. So except few cases, you will not find huge amount of loan from financial creditors on these companies, except where the because of the cash flow issues, they were supposed to borrow from the markets. So this is one of the things. The facts are because the business model was such that a developer used to have some kind of arrangement with the landowner, so there is no expenses involved there. The landowner was taking the part of the built up area, so there is no payment to the landowner until the flats are getting constructed, so zero amount there. Then entire amount for construction was taken in advance from the allottees, so there was a lot of cash flow. In this cash flow, there was a huge component of the cash because they were selling at the price A in real market, but the agreement on paper was happening on the another price. Then the things which were sold was basically on the paper. Like when they were coming out with an advertisement in the newspaper, what they are selling is just the notional allotment. Like they can make a tower, any allotment, anything, it is everything in the air. And once the things were sold, the cash has come in the company. They were supposed to construct, and this money was diverted to the other projects for the reason that they found it an easy mechanism to raise so much of money without incurring any liabilities. So in the beginning, most of these companies which have built these assets are very, very, like, they did not have any big liability as such, except for the money they have borrowed from it. So the challenges are different. There is no land which is owned by the company. The company has taken the money from the allottees and the starting the construction. Construction is yet to take place. And in some cases, there was another entity which was selling these assets. The company who is building was not even selling those assets. So because of this multiple layer of the people, it is getting very difficult to resolve these assets. This is one of the challenges which has not been addressed in this paper, and which there will be another challenge in the RERA for the people who are handling these projects. So siphoning of funds, when we say the siphoning of the funds or the taken of the account, so it's not the siphoning of the funds which is they have borrowed from the financial institution and taking that. No, the fund siphoning of is happening majority of the home buyers' money, which is used because it has come, it's parked in the company with no purpose, so they utilize it another project. And the project kept on leveraging, and it became a systematic problem for everyone. So there are two things. One, every builder is not a thief. And it's another thing is to say that every builder is not an honest person as well. So generalization is bad. Every project has its own nuances, and that's why probably they are coming to the terms with the reality and talking about the project-wise insolvency. Hope that gives some perspective to your question.
No, but I would still see people approaching me for many times that actually their loan will become NPA quickly, see, within a 3 months default actually, because they could not, no flat, nothing has come up actually. But from the perspective of home buyers, actually the RERA IBC is still absolutely very little help. This is my feedback of.
Yes, you are absolutely right, sir. Those people where it is not completed, nothing on the ground, tower is in the air, they are in the worst spot even today, even if these amendments are implemented. But the silver line is that when you have made an investment decision, that there is a risk associated with it. That's the only thing it can be said. But if you have the clients who are approaching, which where there is some iota of construction, even the lenders are there, you immediately can advise them to put forward their case for the as if it's possession. So if in the future it comes, they have at least something to protect.
In
Rather,
many cases, they say that we are paying EMI and other things and nothing is there.
yes, that's the worst cases.
Yeah,
This
that's
is-
the worst case.
That's the worst case where they are paying the EMI and they are not getting the possession, and the project has gone into insolvency and there is no resolution applicant at all.
That is the biggest problem, because see, I have come across with many cases where the real estate persons have taken loan from banks, not only from one bank, maybe from two banks. So the banks go on in IBC because they can do so. But you see, poor individual buyers, they first have to find out, join together 10%. I think none of these laws are friendly towards. So come whatever, of course, there are changes happening, but it is still a far cry for individual home buyers.
Yeah, most of the EMIs and the term loans are fixed by the bank itself with the builder.
Exactly.
And then there's a separate agreement with the home buyers, and they suffer a lot because banks after the home buyers, builder does not do anything. Well, there's a direct agreement between the builder and the home buyers through bank.
No, despite the existence, nowadays every banker, this practice is that there is a tripartite agreement. That is the builder, the home buyer, as well as the banker. But despite all these agreements, finally,
some builders don't go for tripartite agreement.
Yeah, when
They
it comes
say
to
you have an
getting
arrangement between the
possession,
bank and yourself is a separate thing.
Ah.
Hardly there are tripartite agreements where all three agree.
yeah. No, but when it comes to getting possession of the actual house for which he has fully paid, then it's a far cry. It is still with all these amendments, RERA, all those things, it's still a far cry.
It's like a frying pan of fire where to jump. Then a very bad situation.
Yeah. See, as an individual home buyer, see, they are not equipped with any kind of legal thing, all those things, It's a very difficult.
And the emotions are also very high. For a home buyer, the emotional of getting a house and paying owns, it's very, very high. It's full of
Right.
emotions.
Right, absolutely.
There is a small thing which I think the people are not agitating enough. In some of those, in some of those cases, what the banks have done that they have provided the loan, and the people took that loan believing that since bank is giving the loan, so the project is okay.
Yeah, normally, because even the realtor advertises in that big board in the site, this is approved by XYZ bank. You can see it in any site.
Right.
So poor borrower believes that. It's a fact, sir.
Yeah, but nobody is taking these banks to the court to say that it's you who misled us to do this.
Most of the time, the bank pays directly to the builder and EMIs on the home buyers. And they have got nothing.
In fact, the builder advises the home buyers that we will make that loan for you.
It's like home buyers is Than Gopal. Nothing is left.
Right. That's the biggest challenge. So the thing is that at some point of time, somebody might decide to rake up this issue and take all these banks, because see, the thing is that the banks are playing with the public money. They do not have anything to lose or gain out of it. Okay. So sometimes the practices of giving those accreditations and loan to this real estate company might not be fully transparent and honest. And they are again taking the slice at the top of it under 53 when the company is getting liquidated. At
You-
the top of the home buyers, which should not happen. It's double jeopardy for a home buyer.
Yeah, you're getting shot by your own gun. That's the problem.
Right. So somebody has to take up that cause and say that we want to go. It should go against them. Nobody is going against them. Everybody is going against the person who is visible, which is the builder. And sometimes some of them are behind the bar, sometimes have run the way, some of them are trying to save the projects.
And the problem, and so another problem is banks and the builder has a huge legal team. The home buyers is looking for person who can help him out or a legal help.
Exactly. And that's why I attribute the failure on RERA, sir, the act as well as the machinery. They are absolute failure. They are becoming corrupt. You have seen that in the recent one of the raids. No, they are becoming corrupt because it's a place to house politicians as well as retired people.
Yeah, that's true. That's true. One of the allegations of the corruptions are flying left, right, center, against all those authorities. And sometimes
RERA should have transformed into a relief mechanism for the home buyers and provide regulations.
Yes, sir, that's true. Hopefully the system will improve.
Yeah,
That's
keep hopes. That's how the life is.
That's how the life is. So I'll just show the operating part of the judgment. One of the person has said that we can go ahead with showing the judgment. I'll show this judgment in the case of where it is now. Ram Kishore, Union of India. This is in the case of the super tax, so I'll just share. So this is the NCLAT's judgment in the case of the super tech case. So rest of the facts are very project specific. It is given by the chairperson. The operative part, I'm just saying. So the operative part, paragraph, operative part is below, but just let me just show you the questions. So paragraph 14 is relevant. The first, there are so many windows, just a second. Go down. Okay. Yes. First, we need to consider the submission of Learned Counsel of Appellant that in view of the facts, large number of projects of the corporate sector are ongoing projects where substantial completion has been made and large number of units have also been handed over to the home buyers, and the rest units shall also be handed over. In event the construction of projects are allowed to be proceeded against an ongoing project, the promoters or the corporate are willing to extend the corporation to the IRP and carrying out the ongoing projects. It is submitted that the CIRP need not be allowed to continue for all the 20 projects. Rather, it may be undertaken on the project basis as has been held in this tribunal in judgment of the Winter Hills. So the Winter Hills was the cited as the uh, the poster judgment or the landmark judgment for in these submissions. And there are following observations that in the corporate insolvency resolution process against real estate, if the allottees or the financial, this is very helpful for, like this paragraph is really well written. You can cite it for the benefit of home buyers in any case. Okay, so this is what it does. It gives the paradigm which or stark contrast in the words of a financial creditor or in the word of a home buyer. So it says it's a very well written paragraph. In the corporate insolvency resolution process against the real estate, if the allottees or the financial institutions, banks, or the operational creditor of one project has initiated corporate insolvency resolution or is confined to that particular project. It cannot affect any other projects of the same real estate company in other places where the separate plans are approved by different authorities, land, and its owners may be different, and mainly the allottees, financial creditors, financial institutions, financial creditors are different in the separate project. Therefore, all the assets of the company are not to be maximized. The assets of the company of that particular project is to be maximized for balancing the creditors of such allottees, financial institutions, and operational creditors of that particular project. Corporate insolvency resolution process should be subject project basis and as per the approved plan by the competent authority. Any other allottee or financial institution or banks or operational creditor or other project cannot file a claim before the IRP or other project, and such claim cannot be entertained. So we hold that the corporate insolvency resolution process against the real estate company is limited to a project as approved plan by the competent authority and not other projects as are separate place. This is what Winter Hills citation they have cited. Now next, 23. In the facts of the present case, keeping in view the submission raised by the learned counsel for the parties, these are the findings. We are of view that in CIRP process, project-wise resolution to be started as a test to find out the success of such resolution. Keeping an eye regarding the construction and completion of projects, we at present are of the view that interim order dated so and so staying the constitution modified to the extent that the COC be constituted for the project only, with all financial creditors, including financial creditors, banks, and home buyers. The committee of creditors of that particular project shall start process of the resolution of that particular project. The IRP shall separate the claim received with regard to that project and prepare an information memorandum. Accordingly, the project proceeds for the meeting of the COC as per the code. It is further directed that even for that project, the IRP shall carry the project and continue the project as an ongoing project by taking assistance of all ex-management, employees, workmen, etc. We, however, make it clear that Ajay project shall remain apart. So this was the clear theme from the eco-village. So this is the theme. Ultimately, they gave the directions and this matter ended. Then there is another judgment, just a second. Which is an interesting reading. Just a second, let me open this. Just this is the case. This is the second case, Whispering Towers. So in this case, what they have cited is the judgment of the Supreme Court, where it has been SR's observation. And I'll just read paragraph. This is the case. Just a second. The relevant thing I wanted to show is I wanted to show one paragraph where the banks. Okay, I just forgot where I have seen that particular paragraph, but be that as it may, I will just see. Okay. So anyway, I will share all this material with you people, and thanks for patiently listening. If there is any other point for discussion, it's more. I'm happy to take it. Otherwise, we can conclude it. Mm, just a second. Anybody here from coordination team?
Yes, sir.
Ma'am, I think there are no more questions and I have finished my presentation. Can we close it now?
Yes, yes, sure, sir, sure.
Yes, ma'am.
So,
Thank you very much for all the people who have participated, and very much thank you to Matthew sir, Sujit sir, and a couple of people who kept their camera on. Otherwise, it was completely a black screen for me. And all of you are invited for a coffee to my office whenever you have time.
thank you very much, sir, for sharing your valuable inputs on the topic real estate insolvency under IBC. We look forward for more sessions with you, and you are requested to please share your material with us so that we can forward it to the participants.
I will do it.
Thank you.
Thank you.
Now we have next section tomorrow at 2 p.m.